Hi, my name is Jamal Jackson, and I am the CEO and Managing Attorney of Jackson Corporate Law Offices. And first and foremost, I want to thank you for taking the time to view this presentation. Today, what we're going to be talking about is licensing, the basics of licensing. So, first off, what is licensing? Licensing is when someone gives you permission or you give somebody else permission or authority to own or use a product or to use a certain service in trade. As it relates to inventions, it's a grant of rights of uses to reproduce, develop, and/or distribute a product or service owned by another individual. So what can be licensed? Ideas, logos, brands, products, documents, formulas. This is the basic list. However, this is not an all-inclusive list, but these are the general things that individuals license from a monetary perspective in order to gain some passive income by having somebody else do pretty much the legwork based on a brand or service that they've generated or created. Now, the stages of licensing. What we're going to talk about is how do you license something? So, one, you have to have a protectable property right. Two, you need to have the other individual sign a non-disclosure agreement before you talk about the specifics of what you're going to be licensing. And three, we're going to be discussing licensing agreement construction and negotiation. So, just going over some of the basic implications of licensing and how do you negotiate the deal points and terms. So, the protectable property right. In order to license something, you have to have ownership in the idea, and the ownership must be protectable. So we're talking about intellectual property here. So copyright, trademark, patent, trade secret, know-how. And this is a brief definition of each of those terms. So copyright is a protection of works of authorship such as writings, music, and works of art that have been tangibly expressed. Now, copyrights can be federally registered through copyright.gov, but they do not have to be in order to receive protection. Trademarks. Again, a trademark is a word, phrase, symbol, and/or design that identifies or distinguishes the source of goods from those of others. A patent is a limited duration property right relating to an invention granted by the USPTO in exchange for public disclosure of information. So patents are more so talking about technologies and very intricate chemical processes that people have created. Trade secrets are any confidential information or business information that provides an enterprise with a competitive advantage. And then know-how is practical knowledge on how to accomplish a task efficiently and effectively. And it's also generally expressed as expertise. Now, know-how has to be, again, something that gives an individual a competitive advantage over the other players in their industry. Non-disclosure agreement. So why is this important? A non-disclosure agreement is, or as people often call it, an NDA, is important in the sense that it ensures that the secrets and the intellectual property that you share with the third party does not allow that third party to run off with that information and use it for their own accord. So if you share your intellectual property, if it's a trade secret, they don't have the ability to go off and utilize that trade secret for their own beneficial use outside of the terms of the agreement that you all come to. So it states that the information that is being relayed to them can only be used for a specific purpose, and any use outside of that specific purpose is prohibited. You want anyone that you're going to be sharing your sensitive information with to sign this. So a third party, anyone that third party might be working with, anybody that doesn't have direct ownership of the intellectual property or the idea that you're going to be sharing at the time that you share it. And then again, you need to ensure that they sign this prior to any sensitive information being given to them, because that's the only way that you're going to be able to make sure that your intellectual property rights are protected. Now, the third thing is the licensing agreement. Now, the licensing agreement is extremely important because it controls the terms of the relationship. It actually lays out the rules, responsibilities, and obligations of each party as they enter into this mutually beneficial relationship to share intellectual property. Now, the basic considerations, I've outlined 10 of them here. However, a contract for licensing is very extensive, and so there are other things that play into it, but here we're just going to address 10 very briefly. So the length. how long do you want the initial term of the relationship to last? Now, the average contract for licensing is between 3 to 5 years, and they have terms for termination. So typically, those are expressed as a manner of allowing people to get out of the contract before that 3 to 5 years if both parties or one of the parties sees that this is not going to be mutually beneficial. You need to make sure that the term is long enough to adequately assess whether or not the relationship is one that's going to be beneficial to both sides. Now, termination, again, you have to have an exit strategy. You don't want to get a year into it and see that this is not going to be beneficial for either party, but you all have no way to really get out of the contract, or somebody else has licensed your product and they're not handling it in the way that you would like them to, or they're not making sales in the manner that you would like them to, and you haven't given yourself any recourse to get out of the contract. So you have to set parameters around what you will allow as far as your intellectual property goes, and then set performance standards. So this could be a mandatory minimum for revenue sales. You just have to be able to construct some sort of parameters that will allow you to effectively evaluate whether or not this contractual relationship is beneficial, and give you a means of getting out if it proves to not be as beneficial as you thought it was going to be. Royalties. This is very, very important. So how and when will you get paid? So if you are the owner of intellectual property and you license something, you can either do lump sum payments, which everything is paid out up front. You can do fixed payments, which is a set period of payments that are agreed to. So let's say that you are being paid a flat $3,000 every quarter. Running royalty, which is a paid percentage on the sales. Now, some people have a hybrid, so they'll have an upfront payment and then they'll have a running royalty. Now, the running royalties, there are three typical ways that individuals structure these. So one is the excess earnings, two is the residual earnings, and then three is the 25% rule. And we'll discuss those briefly. The excess earnings. So let's say that you have a product and you're licensing a brand. This says what percentage or what premium amount is attributable to the branding that comes along with that intellectual property. So here you see that the branded value is at $50 and the unbranded value is at $40. And then you see that the average cost of goods sold per unit is $30 for the branded, $25 for the unbranded. So all that you do, very simple, you add up these numbers. So you have 20 here, 15 here. The premium is $5. That means that because this item was branded with the intellectual property that you've licensed, it is $5 more profitable per unit. And so you take that and you say that is 10% of the or that premium is set at 10%. So that 10% would be what that running royalty rate would be. Now, the residual earnings, this is where you assess the value to each aspect of the value of the product or service that you are licensing out. So you look at your working capital, fixed assets, other intangibles, and then the two that you really look at, you say the other IP and the subject IP. So you are looking at these bottom two, and you're saying, okay, how much of the earnings are attributable to the intellectual property that I have licensed or that someone else has licensed to me, and you set that. So right here it's at about $15 out of the $50 that is total, that is the total worth of the product or service. And then of course you change that into a percentage, and you get what your running royalty rate is going to be. Now the 25% rule, that this is pretty much used for patents. And so again, you have patents, average unit price, average cost of goods sold, gross margin, and the operating expenses, and then the operating profits. So you take these and you assess what are these numbers for not having a patent, and what are these numbers for having a patent. So anytime that you have a patent, you are able to charge a premium. The value goes up. So you see how much of a premium you have, and here with the patented, it's $40. So you take the $40 times 25%, why they call it the 25% rule, and then you divide that by 100. And when you divide it by 100, you get 10%. And so that's how you get your running royalty. And again, you're saying, okay, how much how much is this product or how much is this product worth based on the patent that someone else is licensing or that you are licensing to someone else. And then you multiply that by 25%, divide it by 100 so that you can get your percentage as far as your royalty rate goes. And again, royalties are something that some people, there are certain industries that have averages for royalties. Those three are just another way to assess royalty rates and percentages, but it's not a perfect science. It is definitely something where people think about how much they feel the royalty rate should be, and then they negotiate. It's one of those numbers that can be negotiated in any situation depending on the amount of leverage that you have when you're coming to the table. And so really think about the royalty rate, and if you have questions, reach out to someone who is familiar with this area, and they can pretty much help you set a realistic and reasonable royalty for the products or services that you're going to be licensing. Now, the other factors that you want to think about, upfront fees. So again, some people have upfront fees and then running royalties. Other risk factors. So if different environmental issues can drastically impact the operations that you have, that's a risk factor to take into account. If there's other pending legislation, or if there are other societal trends that that could possibly affect what you are doing, you have to take those risk factors into assessment. Also, exclusivity versus non-exclusivity. Are you licensing this to one person, and is that one person going to have complete and unbridled ability to use it, or to put this into commerce? So if they're the only ones that you're going to be licensing to, then you're able to pretty much better control the terms, because you're granting them exclusivity. You're saying that no one else is going to have this ability to utilize this IP in the manner that you're going to be using it. Non-exclusivity, that means that they're going to be one of a few or one of many that you're going to give these rights to. And so at that point, you don't have as much bargaining leverage. Now, option to renewal. So is it going to be automatic renewal after the 3 to 5 years of the initial contract? Are you going to set certain metrics to where if they hit those metrics, it'll be an automatic renewal? Are you all even thinking about renewal? That is very important, because both parties need to know, where do we go after this initial term is up? And then territory restrictions. Are you going to restrict them to a state, to a county, to a region, to a country, or is it going to be global? Or are you going to restrict them to certain industries when it comes to them utilizing this intellectual property or commercializing this intellectual property? And then for the scope of use, you have to outline what types of products, materials, content are you allowing them to develop alongside the IP or attach the IP to. So you really want to make sure that you draft a pretty good scope, because you want to make sure that the intellectual property is used for the purposes which you are actually granting the license. Restrictions on use. How do you not want it to be used? Think about ways that could diminish the value. Think about ways that could create brand confusion, or it could place you into a market that you really don't want to be in, and make sure that you put those restrictions within the licensing agreement. Quality control. Quality control is extremely important, because your brand's value, the intellectual property's value, is all about the quality of that intellectual property. So if it's a product, you want to make sure that you set parameters of the type of materials used, the way that it's built and manufactured, and how it's stored, how it's delivered, because that quality is going to ensure that you continue to receive a high value for that product, for that service, for whatever intellectual property you are licensing. Rights of modification. This is just asking, are you allowing the licensee to change anything within the IP? So are you allowing them to modify it to make it better? Are you allowing them to break off certain pieces of the intellectual property and use those in compartmentalized offerings? And then if they are allowed to do that, who owns that intellectual property? This is very important. So if they change or modify the IP, you have to make sure that in the licensing agreement, you are retaining all control and ownership of the new IP that's generated as a result of that modification. Rights of sublicensing. So can your licensee sublicense this out in order to further commercialize it? through a third party that you have no contact with initially. A lot of times, it's not something that licensors want to do because they want to make sure that they are adequately vetting the licensees that they have and controlling the manner in which all of their products are being disseminated. However, if you have a product or service that you feel is something that could benefit from more people having their hands on it, or from a commercializing standpoint, so more people out there selling it, more people out there trying to get it in the hands of consumers, then maybe you want to have the licensee have the ability to sub-license that intellectual property. So if you do this, you want to make sure that you have set parameters. You want to make sure that sub-licensee has to agree to all of the terms of the licensing agreement that you are entering into with the main licensee. Territory, again, territory, city, state, region, nationwide, worldwide, and this can also be broken down by industry. So you really want to think hard about the different markets that you're allowing the licensee to market into, and that's important, especially if it's a non-exclusive contract, because you want to make sure that the licensees aren't going to run into a conflict of interest when they're selling. If you are going after Walmart, you don't want 4 licensees targeting Walmart and approaching different reps or the same rep with maybe different terms and different styles. You want to make sure that there are no conflicts when you're approaching certain consumers or certain purchasers of your products or services. And again, exclusivity. Once again, you have to figure out, is there going to be one person that's going to have sole rights to redistribute the intellectual property, or are you going to be issuing this to multiple licensees? Now, deal structuring is an art. It's not a perfect science. It is an art. And in order to structure a deal properly, you really have to know your product. You really have to know your service. You really have to know your intellectual property. And you really have to know the market that you're entering into. All of this will give you knowledge in how you should structure the licensing agreement. And know that it should be done with the assistance of a professional. This is something that, if done right, could be very beneficial for you, but if done wrong, could be pretty detrimental to your brand or to your intellectual property. So you want to make sure that you are aligning yourself with individuals and professionals who can help you create the best licensing relationship possible. And then be patient. Don't rush to license out your IP, because again, if you place it in the wrong hands, that could be extremely detrimental to your end goal. So be patient. Surround yourself with a team that knows what they're doing, and make sure that you are doing all of your market research, industry research, and that you know your product frontwards and backwards, or your service frontwards and backwards, and you really understand what you're licensing, because once you have a clearer knowledge, you create more bargaining leverage, and you are able to better negotiate the deal points in terms of that licensing agreement. So again, this was just a very high-level overview of how do you license an idea, a product, a logo, a brand. How do you license your intellectual property so that you can commercialize it in a passive sense to where you can realize an additional revenue stream without having to do all of the legwork. Now, it's not a perfect science. It is an artwork, and so it's very important to reach out and consult with industry professionals that are very knowledgeable about the licensing game and who understand how to get you the best deal terms and help you find the right relationships to enter into. Again, my name is Jamal Jackson, and I'm the CEO and Managing Attorney of Jackson Corporate Law Offices, and I thank you for watching this video. I hope it was helpful. If you have any questions, please feel free to reach out. All of my contact information is located on this screen, and I hope that you will tune into the next video, and I will until then, I hope that you enjoy your career, enjoy your business. If you're an entrepreneur, keep doing what you're doing, and I wish you much continued success.